Good afternoon, guys. I have discussion B for you. The article, uh, the article explains what what happens when a person with dementia never signed a power of attorney uh, (POA) and later loses the capacity to do so. It shows that while care and medical decisions still must be made, the family lacks the simple, pre-authorized legal authority to manage finances, sign care contracts, or apply for benefits. So the situation typically requires court intervention or other formal steps. Why no PA creates a crisis? POA creates a crisis. POA must be signed while the person still has legal capacity. So dementia often prevents creating one later. Without a POA, family members cannot legally access bank accounts, sign long-term care admission forms, or apply for public benefits on the person's behalf. The gap forces families to pay out of pocket and can quickly deplete savings. Legal pathways. The article describes 1. Guardianship or conservatorship. Court appointed authority. A judge can appoint a guardian for personal medical decisions and a converser for finances. This restores legal power of attorney to act for the person with dementia. The process varies by state and can take time and money, but it's the standard route when no POA exists. 2. Emergency or limited interventions. Some states allow temporary emergency guardianship or other short-term orders when immediate decisions are needed. These are stop gaps until a full hearing. Spending the person's assets and applying for Medicaid. Families must often use the person's savings or their own while waiting for authority and then apply for Medicaid once eligibility rules are met. Applying typically requires legal authority, guardian or conservator or POA. Financial and practical implications. Timing matters. Guardianship can take weeks to months. During that time, families can be paying care costs. Personally, Medicaid rules require documentation and asset accounting. An elder law attorney can help structure the spend down and prepare the application once legal authority exists. Family conflict and cost are common. Courts may require notice to relatives, and there can be contested hearings, which raises legal fees and delays. Practical next steps. The article recommends talk to an elder law attorney experienced in guardianship and Medicaid planning to start the court process and preserve assets. Document the person's condition and finances now. Medical records, bank statements, property, deeds. So filing and Medicaid applications are ready. Ask the court about temporary emergency authority if immediate decisions or payments are required. Key takeaway. If someone with dementia never signed a POA, guardianship or conservatorship is usually the legal route that restores authority to manage care and finances, but it takes time and can be costly. So early legal help and carefully documentation are essential. Would you like a concise printable checklist for documents and steps to bring to an elder law attorney in your state? Okay, guys, here's the second half of the presentation. Give me a second or two, and I'll have that for you. Okay, this half explains what happens when a person with dementia never created a power of attorney and later loses the capacity to sign one. It emphasizes that dementia erodes decision-making ability and that a POA is the simplest way to authorize someone to manage finances and healthcare. Without it, families face legal and practical obstacles. Core legal implications. Not automatic authority. Family members cannot legally access bank records or bank accounts, sign contracts, or apply for benefits on behalf of a person who lacks capacity unless they have a POA or a court order. Court intervention is usually required. The typical remedy is asking a court to appoint a guardian for personal and health care needs. Decisions or conservator for financial matters. Process varies and can be burdensome. Guardianship and conservatorship proceedings can be time-consuming, costly, and emotionally difficult for families. Practical consequences families face: immediate decision delays, urgent medical or placement choices may be slowed, while legal authority is obtained. Give me 1 second, guys. My papers are out of whack here. Financial vulnerability. Without an authorized representative, the person with dementia is at greater risk of financial mismanagement or exploitation. Family conflict risk. Disagreements about who should be appointed or how to manage assets are common and can complicate court proceedings. Recommended next steps on the page highlights. Talk to an elder law attorney experienced in guardianship and Medicaid planning to evaluate options and start filings. Gather documentation now. Medical records showing cognitive decline, bank and asset statements, deeds, and any prior written wishes. Ask the court about temporary emergency authority if immediate decisions or payment are required. While a full hearing is scheduled. Quick checklist to bring to an attorney or court. Medical evidence, recent physician notes, cognitive assessments, hospital records, financial records, bank statements, investment accounts, retirement accounts, recent tax returns. Property documents, deed to the home, mortgage statements, vehicle titles, list of relatives and contacts, names, addresses, and relationships for required court notes, what to expect from the guardianship conservatorship route, filing and notice. A petition is filed and relatives are notified. The court schedules a hearing. Evaluation of capacity. Courts typically rely on medical evidence to determine incapacity before appointing someone. Scope and oversight. Appointments can be full of limited and often include ongoing reporting to the court about finances and care. Single most important takeaway. If someone with dementia never signed a power of attorney, guardianship, or conservatorship, is usually the legal pathway that restores authority to manage their care and finances, but it requires prompt legal help and careful documentation. Okay, guys, that's your B. I will be back on with C in a bit. For now, Gator Wellness. Take care, folks.